trusts by moving titles in commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
So let's get started here. Welcome everybody to the first meeting of the Trust Ambassadors this Monday, January 18th. I'm your host, Christian Walters, and we just started the recording, so everything's being recorded. I have on here, but if everybody has their Gilbert's law summaries, we'll probably go on a little bit into that, but the primary thing we're going to go over tonight is what I gave everybody for homework on Friday was when I passed out the what's the title of this document? I forget. The Practical Treatise on the Law of Trust by Lewin, the 1888 version. That's the one I have. It's Volume 1 and Volume 2. So we haven't got it switched over to PDF yet to where we can cut it down in size. So I can't display it on the screen. So everybody will have to go along with me. All right. So I'm starting on page 1, which is the introductory view of the rise and progress of trust. So that's the page 1 of the book. That's the introductory view of the rise and progress of trust. Now this is going to be kind of slow going on here because of the word usage that they use. I'm sure that none of us are really familiar with all the terms that they're using in this. So I hope that you struggled along with the first 20 pages and got in as far as you could go, because I don't really expect us to get more than a couple of pages into this each session. But we're going to tear it apart, and we're going to put it back together again, and I guarantee you by the time we're done with the first 20 pages, which is the Chapter 1 and Chapter 2, when we're done with that and beginning on Chapter 3, we're going to know all about trust. Now keep in mind that this Gilbert's Handbook, this is on the statutory trust, but this treatise on the law of trust, this is private trust. So if everybody's got their books open to that, the introductory view, page 1 of Chapter 1 of the rise and progress of trust. So it's fee, fi, fo, fum, fee, fi, fo, fum, fee, fi, fo, fum, I smell the blood of an Englishman. Now if you've read into this treatise, you've got an idea what I'm talking about, because it's really nothing more than feudal times today. So back in 1367 to 1400, when John Waltham, the Bishop of Salisbury, who was the Lord Keeper in the reign of Richard II, he originated the writ of subpoena. And probably just shortly before that is when they really started forming trusts. That's when it all began. So now first paragraph, the origin of trusts. So the origin of trusts, or rather the adaptation of them to the English law, may be traced in part at least to the ingenuity of fraud. So that's the whole thing that really caused trust to come into existence. So by the interposition, now the interposition, we're going to have to look up a lot of these words to know what they're talking about. The interposition in Black's Law, and I'm using the 8th edition, and it would be interesting to find out what some of the earlier editions said, especially when this article was written in 1888. Like maybe a Black's Law 1st edition would be better to appropriate to compare it to, along with the more modern version of the definitions under Black's 8, say. But the definition of interposition in Black's Law is merely stating it as a defense or in defense of. So by the interposition of a trustee, the debtor, or by the defense or in defense of the trustee, the debtor, and right there, that's how they're treating us. All debtors are trustees. So in court, if you're in court as a debtor, you're the trustee. So by the interposition of the trustee, the debtor, thought to withdraw his property out of reach of his creditors. So that's what they were doing. They were pulling the property out of the reach of his creditors. The freeholder, and the definition of freeholder in Black's is one who holds an estate or trust. And keep in mind that also estate here means trust. Freeholder, or the one who holds the estate or trust, to intercept the fruits of tenure. Now the fruits, by definition, is the rents or the income, or the goods derived from the land. So whoever had possession of the property had the right to get the fruits of the land, the rents from the land, or the income, or from the goods. So the freeholder to intercept the fruits of tenure. And tenure is a pretty common word today. A tenure means a right or a term or a mode of holding land. So to intercept the fruits of tenure from the Lord, of whom the lands were held. And then it goes into the church end of it, the body ecclesiastic, to evade the restrictions. In other words, through trust. The church was using trust to evade the restrictions, directed against the growing wealth of the church by the statutes of Mortmain. Now, the statutes of Mortmain in Black's was really the object was to prevent land from being held by religious corporations in perpetuity. In other words, the religious organizations were holding the land forever, and this statute of Mortmain was to stop them or prevent them from putting all the lands in trust and holding them forever. So the growing wealth of the church by the statutes of Mortmain. So another inducement to the adoption of the new device, and that new device, that's trust. So the adoption of the new device was the natural anxiety of mankind to acquire that free power of alienation, and alienation means transfer. Power of alienation or transfer and settlement of their estates. And remember, estates is trust. So it's the power to transfer in settlement their trusts. So by the narrow policy of the common law. So this gives us the reason why they've been doing it all, because this is the reason, the motive behind it all, which is why they flipped everything in 1933 away from common law. So that they were looking at common law as being a narrow policy, and they wanted to change it because they didn't like it. So what they did is they cooked up things like trusts. So the narrow policy of the common law, which was under the common law, they had hitherto been prevented from exercising. So this common law was preventing them from doing what they wanted. And this is the real reasons why they came about the 1933. So that's the real reason. Now the next paragraph, the subpoena. So originally the only pledge, and pledge in Black's law is a promise or undertaking or a security to the duty. In other words, it's a bond. And my bond is my word or my pledge or a trust relationship. So originally the only pledge, or originally the only bond, or the only duty for the due execution, and execution is putting into effect. So the pledge for the due execution of the trust, or the putting into effect the trust, was the faith and integrity of the trustee. So theirs was the pledge of the trust. The trust was in the trustee to do his duty. But the mere feeling of honor proving, as was likely, when opposed to self-interest, in other words, the trustee got greedy. He decided to keep the property for himself, since there really wasn't anything in writing. So when opposed to the self-interest, an extremely precarious security, in other words, the pledge, as mentioned above, and the pledge was the bond, or the undertaking, or the security. So that's when John Waltham, the Bishop of Salisbury, who was Lord Keeper in the reign of Richard II, originated the writ of subpoena, by which the trustee was liable to be summoned into chancery and compelled to answer upon oath the allegations of his sedicii trust. And sedicii trust, by definition, is beneficiary. So he was supposed to be compelled to answer under oath the allegations of the beneficiary. And that sestuike, which we've been mispronouncing, that's the way it seems to be if you pronounce it by looking at it, but it's set, S-E-T, and then T-E-E, and the second word is K-E-E. So it's sedicii. So I have to get deprogrammed from where I've been mispronouncing it and try to pronounce it the correct way. But anyway, sedicii trust is the beneficiary. So continuing on, no sooner was this protection, the subpoena, extended than half of the lands of the kingdom became vested in feoffees to uses. And now feoffees to uses, the feoffee is the trustee, and uses is also trust. So it's the trustees of the trust. So half the kingdom became vested in feoffees to uses, or trustees as trust were then called. So thus, in the words of the Old counselor. The parents of the trust were fraud and fear. And the court of conscience was the nurse, or the nanny, in other words. So AKA the courts and its conscience became the nannies. So when I read this, I thought, man, that's very interesting. I never realized what the real use of the subpoena was for versus the summons. Because you only get summoned in once. Summoned into court with a summons, with the original complaint. But then after that, everything after that is a subpoena. Well, the subpoena is for the real man, and the summons is for the corporations. Because they're summoning the corporations into the court, and then whoever shows up in response to the summons is the real man or the surety, who is going to pledge as the security for standing in as the trustee. But the real man was supposed to be summoned in with a subpoena, not the corporation. So I thought that was very interesting. So let's go to the second page. Page 2. Trust simple or special. Now, simple trust, that's where the trustee he is passive in his duties, and the special is where the trustee is active in his duty. He has an active duty in managing or administering the trust. So a simple trust defined, or the passive, of trust were two kinds, the simple trust and the special trust. So the simple trust was defined in legal phraseology to be a confidence. Now, confidence is really two words put together from the Latin. It's based on two words, con and fidens. And fidens really is Latin for fidea. Fidea means faith, and con means living. So confidence is really living by faith. It's a relationship of living by faith. And remember, the bond or the surety is the confidence. So this phraseology, to be a confidence or living by faith, not issuing out of the land, which is really the title. The land is the title. We're talking about the title. But as a thing collateral, annexed in privity. And privity in Black's law means knowledge. You have to have knowledge to have privity. You know something. So it's annexed in the privity or the knowledge to the estate. Remember, estate is trust. So it's knowledge of the trust of the land. And to the person touching the land, solicitous, which is really, that is to say, and that's the same thing as what you have on your notarizations there when you do an affidavit, it's SS dot. So that is to say that the sedicee use, or the beneficiary, should take the profit. And remember, the profit is the income or the rents from the land. And that the terra tenant, and the terra means, by definition, land, so it's the land tenant, the profits from the land tenant, should execute an estate. And remember, estate is trust. So execute or carry out a trust, as he should direct. And that's as the trustee. So in order rightly to understand what was meant by this rather technical description, so that's a technical description there, we shall briefly consider the principles that were recognized by the courts of equity. And here's the bingo. For these had the exclusive jurisdictions of trusts. So trust operates solely in equity. Just what we've been saying. Now keep in mind that the uses equals trust and fee-off equals trustee. Fee-off-e, equals trustee. So the EE on fee-off-e equals trustee. The double E on the trustee, same thing. So continuing on. First, with reference to the terra tenant or the land tenant, or the fee-off-fee to uses, or the trustee to the trust. And secondly, with reference to the beneficial proprietor or the sedicee trust, which is the beneficiary. So it's secondly with reference to the beneficiary. And that ties in with the principles of this technical description as above, which trust had exclusive operation only in equity. So now we get into the next paragraph. And remember, confidence is the relationship of living by faith in the person. And they were talking about that person was really the trustee, and the trustee was, by his own selfish interest, he decided to abscond with the property. So now the beneficiary is not getting any assets or any income from what, he should be. The disbursement, the trustee is withholding it. So the confidence in the person. So with respect to the fee-off-fee, remember that's trustee, to uses, and the uses is trust, it was first held to be absolutely indispensable that there should be confidence in the person. So they're talking about the trustee. And privity of estate, or knowledge of the trust. For want of the request of the personal confidence, which is the confidea, or the living by faith, it was ruled that a corporation, in other words, a fiction, could not stand seized to a use. And stand seized means to put into possession, to a use, and that means trust. So it means put in possession with the trust. So a corporation could not be put in possession by a trust. For how it was said, could a corporation be capable of living by faith, confidence, when it had not a soul? Nor was it competent for the king to sustain, and sustain under Black's means to maintain, the character of the trustee. So neither could the king become the trustee. For it was thought inconsequent to his high prerogative that he should be made responsible to his own subject for the due administration of the estate. And continue on. And originally the subpoena lay against the trustee himself only, and could not have been sued against either his heir or his sign. For the confidence of the living by faith was declared to be personal. In other words, only for the person, the trustee, who had the duty, and not to accompany the devolution, which devolution, Black's, is transfer of rights. So it's a transfer of the rights of the property. So, or transfer, that devolution could also be through foreclosure. Your rights are being transferred under a devolution, a foreclosure, or an arrest. But the doctrine of the court in this respect was subsequently put on a more liberal footing, and it came to be held that both heir and assign should be liable to the execution of the use of the trust. An exception, however, was still made in favor of a purchase for valuable consideration not affected by notice. So that corresponds with a lot of things, especially in UCC, where a party can be a bona fide purchaser if he has not had notice. But if he has been given notice, then he can't take the title free and clear because he's had notice, unless he was the holder in due course, and that would cut all other parties off. So now we get into the privity of estate. And privity of estate in Black's law is a mutual or successive relationship to the same right in property as between the grantor and grantee, or the landlord and tenant. So if some of you have a warranty deed, if you get your warranty deed out and you look on the terminology in there, it will probably say that the grantor was the previous seller and the grantee is the new purchaser. And then you went and recorded this into the, or had recorded this into the county, which a trust was formed, and you were the trustee, because grantee is the same as trustee. And here we're talking about privity of estate, and privity means knowledge. Knowledge of the estate. Remember, estate means trust, so it's knowledge of the trust. That's privity of estate. So in the privity of estate, continuing on, the meaning of privity of estate, or privity of trust, next page 3, be best illustrated by an example. And here's the example. Had a free offment. Now, free offment in Black's law was defined as the act of conveying land in fee simple. In other words, that's a conveyance. So a fee offment is a conveyance. So it had been made. Okay, I'm back on. Can you hear me? Hello, can you hear me? Somebody unmute.
Yeah, this is Mike. I can hear you.
Okay,
Mike, it's Matthew. I can hear you again.
Yeah, where'd I leave off at? Where'd I got dropped?
Top of page 3.
Top of page 3? Okay, I just got into the illustration then, right? The example. Okay, had the fee offment, which was the conveyance, because fee offment means the act of conveying land in fee simple. So had the conveyance been made to A for life to his own use and use as trust, to his own trust, with remainder to B in fee. And fee means interest. So interest or fee to the use or the trust of C. And then A had an oft, D. And an oft means put into legal possession. So A had an off D in fee, which is the interest. In this case, though D had the land by the fee offment, and the fee offment was the act of conveying the land, which then operated as a tortuous conveyance, or tortuous means wrongful act. So the wrongful act of the trustee of holding the property. So yet he had not taken the identical estate, or the trust, in the land to which the use, or the trust, in favor of C was attached. An attachment means transfer under Black's. He was not bound by C's equitable claim. And you'd really want to talk about the claim. You'd want to look up bill in Black's law. And it's really a bill to compel. And continuing on, by the same rule, neither the tenant by the courtesy, and courtesy is where a husband's right upon the wife's death to life, estate, and land that his wife owned, assuming that a child was born and alive. So that's courtesy. So neither the tenant by the courtesy nor tenant in dower, and dower means a wife's right upon death of the husband to a life estate, and 1/3 of the land that he owed or an interest. So nor tenant in dower, nor tenant in legit. And legit, Black's means judgment. Legit means judgment. Make everything legit by a judgment. Everything is all legit. So nor the tenant by a legit or judgment was liable to the execution of the uses. And execution was the legit, everything making it made legit by the judgment, the execution of that for the trust. For their interest, and interest were new, and new means recently come into being and unfamiliar. So the new and original estates. Now, original estates is very interesting. So original estates, and could not be said to have been impressed with the use. So now original estate is the first one, or the derivative estate. So it's a derivative. It's a trust derivative. So original estate is the first one, or the derivative estate, in other words, it's been securitization, bearing to each other the relation, which is the trust, a relationship is a trust, of a particular estate and a reversion. So the original estate is the first one, or the derivative estate, bearing to each other the relationship of a particular estate and a reversion. And now reversion under Black's is the interest left after subtracting what the transferor had parted with from what was the original estate. So what was left was the reversion. And that was the original estate, or the derivative. But the derivative is also a securitization device. So that's the original estates. So the interests were new, or unfamiliar, or just recently came about, and these were the derivatives, and could not be said to have been impressed. Now, impressed is a very interesting word also. So I have to look with impressed in the book here, because the definition was too long, and I didn't write it on my side column there. Impressed in Black's. Okay, my Black's does not quite have impressed, but I picked out one that was close to it, which is probably derivative of impressed, which was impressment. Impressment. It says the act of forcibly taking something for public service. That was one. Number two, here's a bingo. A court's imposition of a constructive trust on equitable grounds. See constructive trust under trusts. Bingo. And also, as an archaic term, it says the method by which armed forces were formally expanded when so-called press gangs seized men of the street and forced them to join the Army or the Navy. So you were impressed into service. So I was really impressed by how you used that term, or how you used that land. But what was I really saying? Was I saying that the constructive trust that was formed under equity was really under trust? They're saying here, impressed with the use, and use means trust, and impressed means also the court's imposition of a constructive trust on equitable grounds. Equitable grounds, that's where trusts solely operate, remember we said. So the Lord who was in by Ischit, and they have that in word italicized. And in Black's law means under or based on the law of, and that is to bring an action in contract. And we all thought we knew these definitions. So the Lord who was in by an action in contract, by Ischit, and I have to go to Ischit in Black's law also because the definition was so long and I didn't write it in.
Christian?
Yeah.
What page, what book and page are you on? I got in late.
Okay, I'm on page 3 of the treatise on the law and trusts.
1858?
Yeah, the 1858, yes.
Thank you.
And I'm also looking up the definition of Ischit, so we're like 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, about 11 lines down from the top of the page on page 3.
Ischit, right of state to an estate left vacant, no one to claim it.
Yes, I was picking up where so the Lord who was in by Ischit. And in means, by definition of Black, means by an action in contract. So Ischit in Black's Law 8 says the reversion of land ownership back to the Lord when the immediate tenant dies without heirs. So they're talking about the reversion, or just like we went over in the definition of the original estates. Remember, the original estates was the first one or the derivative estate, bearing to each other the relation of a particular estate and a reversion. And reversion, by definition, was the interest left after subtracting what the transferor has parted with from what was the original estate. And then back to Ischit and Black's, the reversion of land ownership back to the Lord when the immediate tenant dies without heirs. Well, that immediately brought the straw man is a fiction without a soul and is dead and has no heirs. And number 2, then, of this definition of Ischit, reversion of property, especially real property, to the state upon the death of an owner who has neither a will nor a legal heirs. Does the straw man have a will or any legal heirs? So then everything has gone to Ischit back to the state. Number 3 definition, property that has so reverted. Now the small print says, quote, all escheats under English law are declared to be strictly feudal and to import the extinction of tenure. The rule was, and if lands were held in trust and the sedicii trust without heirs, the land did not escheat to the crown, but to the trustee. Being an esse in the legal season of the land, took the land, here's the point, took the land discharged of the trust. Discharged of the trust, and bound as owner for the feudal services. But as the feudal tenures do not exist in this country, there are no private persons who succeed to the inheritance by escheat, and the state steps in the place of the feudal lord, by virtue of its sovereignty, as the original and ultimate proprietor of all the lands within its jurisdiction. And you think you own something? You're working as a fee-fi-fo-fum in feudal times on the state of fiefdom. So continuing on page 3 there. So the Lord who was in by the action and contract, by escheat, a descensor, I might be mispronouncing these, but anyway, according to Black's, descensor is a person who wrongfully deprives another of the freeholder possession of property. So in escheat, the descensor or the abator, and the abator is a person who interferes on the heir's freeholder before the heirs takes possession. And an intruder. So an intruder is one who intrudes upon the whole thing. But these were not amendable or legally answerable to the subpoena. For the first claimed by title paramount to the creation of the use or the trust, and the 3 last were seized or put into possession of the tortious estate and held adversely to the fiat to usus or the trustee. So you might want to warm up your Gilbert's book and turn it to page 130 and be ready to read into section 456 on the Gilberts. But now I'm going to go to definition of blacks on bill. It says a bill, number one, a formal written complaint, such as a court paper requesting some specific action for reasons alleged. And two, an equitable pleading by which a claimant brings a claim in a court of equity. Court of equity, okay, I like that. Before the merger of law and equity, which is what they did and completed it in, I think it was 1966 or 1968, the bill in equity was analogous to a declaration in law. Now remember, according to what we've been studying under declaration was really a method of formation of a trust. Can be. So the 9 parts of every equitable bill are, number 1, the address to the persons holding the Great Seal. Number 2, the introduction which defines the parties. And number 3, the premise which state the plaintiff's case. 4, the confederating part, in which the defendants are charged with combination, count 1, count 2, count 3, whatever. And 5, the charging part, in which the plaintiff may try to overcome defenses that the defendants may allege. And 6, the jurisdictional clause, showing that the court has jurisdiction. And 7, the interrogatory part, or the interrogatories, inserted to try to compel, that's where equity is, equity compels, to try to compel a full and complete answer. And 8, the prayer for relief. And 9, the prayer for a process to compel. That's where trusts ride in equity, and equity is the means to compel something from being done that is illegal, or get you to compel to do something that you should have done. Case of, say, breach of fiduciary, breach of trustee duty, or breach of trust. So 9, it says again, the prayer for a process to compel the defendants to appear and answer. It is also termed bill in equity, and C, declarations. And I went to declarations. And declaration is a formal statement, or a proclamation, or an announcement, especially when embodied in an instrument. And keep in mind, everything that you sign is really an instrument. And then I jumped down to declaration of trust. It says an act by which a person who holds legal title to property or an estate acknowledges that the property is being held in trust for another person or for certain specified purposes. And 2, the instrument that creates a trust. Now I'm trying to figure out where we left off at on the article here. We were talking about the first claim or the bill. And where's the bill at? Okay. The equitable claim. I was at about 1, 2, 3, 4, 5, 6, 7, 7th, 8th line there. Right there it says where C was attached or transferred, he was not bound by C's equitable claim. And the bill to compel, which ties in with the subpoena that they were talking about, which was you were subpoenaed into court, you were compelled into court to answer through the beneficiary's claim. And the beneficiary's claim is an equitable claim, the equitable claim they're talking about here. So by the same rule, neither tenant by the courtesy, nor tenant in dower, nor tenant by legit was liable to the execution of the use, for the interest were new and original estates, or original trust, and could not be said to have been impressed into service with the use or the trust. So the lord who was in by escheat was the person who was wrongfully derived another of the freehold possession of the property, the Caesar, the abater, the intruder, and he was not amenable or legally answerable to the subpoena. For the first claim by title paramount to the creation of the use or the trust, and the 3 last were seized, put in possession of the tortuous estate or by the action, and held adversely to the fiafi to uses or the trustee. And remember, the estate was the sovereign through the escheat. It reverts back to the state because they're claiming to be the first holder. They're claiming to be the lords. Now we'll jump to that page 456, section 456 on page 130 in Gilbert's. somebody asked me one of the calls back maybe about a week or so ago, 2 weeks maybe, and I told them, check out the bill in equity. And I ran the definition of bill in Black's Law. And under number 1, section 456, on page 130 of Gilbert's, it says the creditor's bill in equity. So at common law, a beneficiary's interest is not subject to execution in the strict sense. The usual procedure was, and in many states still is, to file a creditor's bill in equity, or its equivalent, alleging no adequate remedy at law. That is, that the judgment creditor had sued out a writ of execution, and we've been talking about execution in this other document, the summons, writ of execution, which was returned unsatisfied. The equity court, in other words, the private side, could then decree that the trust income, or in other words, the strawman account, otherwise payable to the beneficiary, be paid to the judgment creditor to the extent required to satisfy the judgment. So this is really, look up bill in Black's Law that I just read and compare that is really as a declaration. But it's a declaration as to what? Because, in other words, that's a portal term again. It can be construed to be under trust, or it could be construed to be under debtor-creditor. But since you didn't express it to be trust, and it is going to be construed to be under debtor-creditor, you're going to be owing the debt under debtor-creditor because you didn't express it. If you had expressed it or declared it under trust, then it would have been treated differently. It would have been a record of the payment instead of a record of the debt, because it would have been a special deposit. So this is how they're leaning up the trust under the modern view, and why the protective trust was formed under an older view. And they are now bleeding the assets in the trust under a construed modern view. To the point probably won't be any assets left. In other words, they're usufruct. And usufruct in Blacks is what they're using to get you. That's U-S-U-F-R-U-C-T. Usufruct. Latin. Usufructus. Roman civil law. The right to use and enjoy the fruits of another's property. Another's property. For a period without damaging or diminishing it. Although the property might naturally deteriorate over time, in Roman law the usufruct was considered a personal servitude, giving a real right. In modern civil law now, the owner of the usufruct is similar to a life tenant, and the owner of the thing burdened is the naked owner. Then if you read the small print, you get a better explanation of that. But down about 3/4 of the way in, it says, a usufruct might be in land or buildings, a slave, or a beast of burden, and in fact in anything except things which were destroyed by use. Destroyed by use? Well, remember, use is really trust. So, are they destroying things by trust under a modern view? Under a bill that was not expressed to be under a trust, but being construed to be a debt, which is giving them, under the modern view, the ability to bleed the trust assets? That's the way I see it. Under the disguise of the Founding Fathers who gave us the unalienable rights in 1776, and unalienable in my mind means not transferable, period. But since they're construing it because nobody's saying anything about it being a trust at all, gives them the right to say, okay, we're going to change things around in the modern view because in our best interest, we're going to do it this way. Nobody says anything different. So they're going to form a protective assets because nobody paid the previous war debt, 1776. So 1865, they may have formed a protective trust. Took the assets in 33, and then under the disguise of saying, well, the creditors are coming after the beneficiary's assets, and we're going to put a protective trust on it, a discretionary trust now, and it's for the discretion of the bankruptcy, since they stopped paying their debts, even though they had the assets to pay them, because that's the definition of insolvency in Blacks. It says, even though you have the assets to pay, you choose not to pay, and you are bankrupt. You are insolvent. And they said, okay, give us all your gold. We'll hold it in trust deposit for you so that your creditors won't have any chance of getting it. But then we went through this second set of bankruptcy law rule from then, and then we come into this new phase, let's say after 70 years or the third go-around or whatever we want to call it, And now they're going to come and they're going to bleed the trust dry because you are being, by prescription. You're being prescribed. And prescription was, after an amount of time, they're going to take your rights away from you, which ties in with what we've been talking about, some of these older definitions. Prescribed or prescription in Black's Law. Prescription, getting there somewhere. Prescription, the act of establishing authoritative rules. A rule so established, also termed prescript, number 3, the effect of the lapsed time in creating and destroying rights. They're going to destroy our rights. And number 4, here's the big one. The extinction of a title or right by a failure to claim or exercise it over a long period. We fail to express the trust or fail to state a claim under trust. And over a period of time, a long period of, say, 70 years times 3, 210, they're going to take and extinguish the title or the right. And they're going to take everything over. And we're going to be the slaves. And it's all prescribed or prescription. So let's open it up for some questions here, because I think that's where I'm going to stop for right now. So has anybody else done a word study on this so far? And do you get the same meanings out of this that I do? Has anybody looked up all these words in Blacks and gone over them?
Yes, Christian, I have.
Who's this?
Robert.
Hi, Robert.
Wilmington, North Carolina. Yeah, I looked up about 35 words, and they're right on. I'm using Black's 5th and 1st. I don't have the 8th yet.
Okay. Does that kind of comport with the same? Because I was using mostly the 8th there.
Yeah, exactly.
It'd be interesting to find out through the first Blacks, because that's closer, I guess, 1910, I guess, is that with this treatise, which is 1888. It'd be interesting to see how that compared to, say, with the Black's 8th. But I mean, I read this thing, and I'm going through this, and I'm saying, my gosh, this is like a blueprint that they've been doing, and how they've been doing it, except they've been hiding it because they use all these archaic words that we don't use today, and they flip the meanings, and they get us to talk about things like, well, we use every day. Words that we use every day that don't have the same meaning because they're really using the old definitions, I believe.
Christian?
Yes, go ahead. Is this Donna?
Hi, this is Donna Lee from Florida. Yeah, how you doing tonight?
Good. Go ahead.
I looked up every word. I looked up the definitions. My head is absolutely swimming, but I'm so motivated to do this because it's like almost everything I've ever believed to be true as far as definitions. So it's done a whole 180 on me. Right now, my head's still swimming with all these definitions and everything, and at this point, I mean, I'm definitely going to defer to your definition and how you're reading this because you've been doing this for a heck of a lot longer than I have. So, but the way that you describe it, I mean, it makes all the sense in the world that that's how it would be, that's of the descriptions. But what can we do about that? I mean, if only 1% of us express the trust and do what we should do and claim, make our claims and everything, I mean, is that going to stop the steamroller coming over us?
I can't really answer that, but I know one person could pay the whole national debt off. And if the national debt was paid and all the previous war debt, and then if that person didn't get into debt in the future, then that person is not a debtor in the fiat currency of democracy private, a.k.a. United States. They're operating totally in the private. They're operating totally where equity is, in trust. So I think it's possible.
I'm kind of concerned about...
Go ahead.
Christian?
Yeah, go ahead.
Yeah, this is Michael out of Texas. Kind of concerned about something in what you read, the Creditors' Bill of Equity. That's going on right now. There was a lien put on U.S. Treasury for $47 trillion by the Chinese and the UK on 7th. And this is what they're doing, right? About ready to close the book.
Yeah, right. And
they're doing it right now. So we might be out of time.
Well, Don't know till we try.
I don't know. Chris is pretty brilliant here. Can't we put a bond on their lien, like a higher bond?
Okay, what we got to remember now is that what the Chinese are foreclosing on is the fictional treasury of the United States, not the real land.
Yeah, but they're going because if you read the credit bill of equity, 456, what he just read, that's basically taking away the real man's assets and going after our gold.
Well, I think
closing down everything
is kind of right, because remember, this Gilbert's Law is the statutory side, which is the fiction side, and it's not the private trust, it's the fiction trust. So it's a mirror image in reverse. So they may be coming after the fiction currency and going to drain that trust dry of fiction currency. It may be drawn against the real assets held in private still, and we still may have time to correct that problem.
If I can add my 2 cents to that, I don't think the de facto United States could be touching the trust money at all.
Probably not, because it's supposed to be held in trust unless they want to breach the trust.
Exactly.
And they've done a pretty good job of keeping the trust, the assets, protected.
And on the other side of worrying about things, there was an interesting article that came out of Japan today by a gentleman named Benjamin Fulford, and there's quite a few people besides the Chinese government, another organization that's very well in tune with shutting down the IMF right now.
Well, I think they're in a sense of reorganization. They're shifting the balance of control from the United States to, say, Europe someplace. But really, remember, they're still all fictions. They're still all fictions, and fictions have to be empowered by a real live man somewhere. They got to get a signature on anything that they do. Fiction is going to do nothing. Really, we're doing the whole thing to ourselves, and we have to get a grasp on that they're doing nothing without us. We're powering the whole thing. We have to learn how to shut off the current so that it shuts them down. How do we do that? Well, I think that's an expression of the trust. Take over those accounts. Get your IMF and the IRS, get it all straightened out so that all other agencies are in line with that, so that we can make a payment for the past debt, present debt, and then the purpose of the trust ceases to exist, and it ceases to exist. It's kind of like on the whiteboard here. If we drew a circle here, at least we try to draw a circle.
Here it is.
And then this is like, it's like nothing. So we take nothing and we divide it into half. And when we divide it into half, we've got something and we got anti-something. But when you bring both of those together again, you have nothing. So this line down through the center, this is the trust. The trust is separating both sides. And America and the Republic are in the asset side with the common law. And over here is the public. And you can't see one side from the other because of that line. It's like a mirror. It reflects it back. You can't see through it. But the moment that the trust purpose ceases, then the line comes down. It's just like merging the two titles, because these are two sides, two titles to the trust. And when they're merged, the line comes down, they're all one again. So I think what we could do is we could use this smaller circle at the top. That's the straw man pass-through transmitting utility from one side to the other. If we take a title from the asset side, and we take a title from the liability side, whatever it is, over here is the debt, and we merge that title into that straw man entity, and we merge this title from the asset side into that straw man entity, and you just discharged under trust. Trust on the public side, discharge on the public side, or set off on the private side. And basically that's the model that we're going to be using to do everything, because it's all the same thing. So that straw man account, all the other subtrusts at the top there, this straw man account, all these other subtrusts on the public side, your court case, your IRS, your gas bill, groceries. All of these trusts, these sub-trusts over here, are trying to gain access to this straw man trust so they can get to the asset side. But since they block that, everything piles up on this liability side and adds more to the national debt, and we can't use the discharge or the set-off to balance things back and forth. And actually, the pressure on this side keeps on going up, or the national debt, to the point to where everything comes to a bust. Where if we had access to this side, we could relieve the pressure and bring everything back down to a balance at the end, because really this is all just accounting. And there's your T account, and now you have set off or discharge, and you brought everything back in balance. So that's the way I look at it. It's all about moving titles, and if we don't have a title, we can always create a title. And remember, fictions can't do anything. They're always looking for your signature. If you don't give them your signature, or you give them your signature in a restrictive way, in an expression of a trust, and then you know and you understand what's going on by this treatise on the trust here, and Gilbert's Law Summaries, and whatever else we may read to come across. Now we have knowledge and understanding, and we know how to play both sides of this ledger, and we gain control of both sides of it, and we can balance the accounts. Any comments?
Well, it makes sense.
How far did everybody get in the book so far?
I got to chapter 4.
Chapter 4? Well, you're way ahead, huh? Yeah, even a brief read, if you go through it, you would just get familiar with the terms. That'd be better than nothing at all. Well, any other questions, comments?
Christian, I think it's really interesting how when you merge the titles, it's supposed to terminate everything, because theoretically in science, if two identical things cannot exist in the same location, and but I'm trying to wrap my mind around this, because it's like a mirror image, right?
Right. Yep.
It's just amazing. I'm just trying to get trying to wrap my mind around this. But I think it's absolutely fascinating. And the more I learn, the more definitions that I go through, the more it makes sense, and the more excited I get. So I think it's absolutely fantastic.
So, Christian, let me ask you. We got 1934, the Senate issues their document number 43 in the 73rd Congress that says, the ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government, that is, law amounting to mere user, and use must be in acceptance with law and subordinate to the necessities of state.
Right, that's coming from the private side, or I mean the public side, excuse me.
Right, that's coming from the public side. So that is your wall right down the center of your circle, isn't it?
Yeah, that sounds like it, yeah.
So how do we break that one down, Mr. Reagan?
Well, they're construing the trust to be under debtor-creditor, which was just like you said, the law that's separated the thing. But trouble is, it's really a trust. It's really
yeah, understanding that, but even looking at this, rise and progress of trusts, when we got into this one section here that said the Lord who was, by contract, upon the death or the mortmain, the dead man, the dead hand of what you so rightly pointed out was the straw man, it can't be subpoenaed.
Right, he's summoned. That's what they do when they come in with a summons. They summon the fiction into court with a summons. And whoever shows up is the one assumed to be the surety or the bond or the pledge.
Okay, so now they're hoping that that summons will bring in a living man, because there's no commercial energy without the living man.
Right.
So when we show up, we are, I've had it said to me before in court, well, I could stand and say, well, I'm not the fiction you're after. And their comment is, well, you're here.
Right.
That wall, that line in the middle of your circle here seems to be what's causing all the problem. And I guess, I'm just trying to cut to the chase, and I agree with your diagram. I see the public and the private. I understand the positive and the negative, the commercial energy. I get all that. The question is HOW. How do you pierce that wall? How do you reverse that mirror image?
Well, I have to learn how to control both sides, and what we're doing is what you came into court. Once you got summons into court, you didn't summons them into court with the mirror opposite of that, which was your counterclaim.
Okay, so bringing the counterclaim in by expressing or declaring the trust, claiming the grantorship under that, would be, in essence, reversing the roles. Now they've got to answer. Is that what you're saying?
Right. You summons their corporation in, and then see who shows up. And if somebody shows up, we're going to use a summons, and we're going to summon somebody into an in-chamber, in-camera hearing where equity for the trust operates.
Okay, I get that. Now we're in camera. We're in chambers. We're having this discussion. We're dealing with whatever issue we're dealing with. There has to be a meeting of the minds, because regardless, it's still contract law.
A meeting there. Really, when the beneficiary makes a claim after he's proved trust, if he makes a claim that hasn't been paid, he makes a prima facie case for that after he's proved the trust. The court of equity is going to assume by presumption that the trustee is guilty, and the burden of proof shifts to the trustee. And the only thing the court wants to know at that point is, did you make a payment? And if you didn't, when are you going to make a payment?
Well, who are we considering to be the trustee at this point?
Well, the trustee is really the United States, and the beneficiary is we.
So when they form this constructive implied set of key trust, however you want to say that, there is no grantor in that. There's only co-trustees and co-beneficiaries. And if we're going in as the beneficiary,
grantor would be the one who granted the assets, and that would be we the people. The we the people are grantor beneficiaries.
But you're going in as a beneficiary into equity.
Yes.
Claiming that the trustee didn't make the payment.
Right.
So what is your grantorship? How do you? I guess you're saying you establish your grantor position when you're making a declaration of the trust.
Yes.
And then you're looking for remedy as the beneficiary.
Right.
And asking the state to affect the remedy.
Asking the court.
Because you've merged titles?
Well, I could merge the titles,
you're not terminating the trust at that point, are you?
Say again?
I say you're not terminating the trust at that point, are you? Are you merging titles at that point? Or you're just looking for remedy and performance, compelling the trustee to perform?
Well, there's two ways I can do it. I can force the trustee to do his duty through a court of equity. The court will force him, compel him to do the duty. Or I could come in and merge the titles and terminate the trust. And now the trustee has no protection under trust, and he has a duty to perform because the trust must be terminated. He has to do the disbursement. So either way, I'm in a win-win situation.
And the key to this whole thing would be then to get the summons and have someone answer.
Yeah, the summons is the counterclaim, which gets them their corporation to come in and answer, and then you do the in-camera hearings.
Wow, looks good on paper.
Christian?
Yeah. Go ahead.
Christian, isn't in trust law the only way to get somebody into court the subpoena?
Would everybody please mute out R6, and could you repeat that again?
Yeah, we were talking about summoning these people to the court. Is in the trust law the only way to get someone into court the subpoena?
Well, no. I mean, you could do it at law, but I would want to come under the equitable side because that's where the real man has his real substantive rights. At law is just the public side, which is all fixed and stuff. You have statutes and codes. You're the debtor on that side. I want to operate solely on the private side under equity, and that's the key. I think that's the key point that we've all been missing is that there was two sides to the court and how to stay on the one side, the private side. I gave a definition of state secrets, and state secrets in Black's law was state secret, a governmental matter that would be a threat to the national defense or diplomatic interest of the United States if revealed. And remember, we're all diplomats or ambassadors. We're foreign to the United States. And really this would be a state secret. And they don't want to get this out of the public because that would be making the public aware. They don't want to do that. So continuing on, it says, information possessed by the government and of a military, and here it comes again, or diplomatic nature, the disclosure of which be contrary to public interest. So they can't let this stuff get out because it's contrary to public interest in their realm. So state secrets are privileged matter from disclosure by a witness in an ordinary judicial proceeding. So there's where our privileged matter comes in, our trade secret or CCI, confidential commercial information, which we will put a protective order on, which defines it as being secret. It's only to be discussed in chambers, say, for judges' eyes only. Because if we bring it into the public in any way, according to the evidentiary rules of their realm, under 501, and which comports down to everybody's local rules in their state, and in particular in Florida, I keep coming back to this, is 90.501 through 510, but in particular 90.506, which states it's privilege with respect to trade secret, and 90.507, which is waiver of privilege by voluntary disclosure. And then I went over this a little deeper, I think it was last week, when I talked about out of this Florida Federal Evidence Rules book here, which gave us some explanations on to, exactly what happens when you open your mouth in court and talk about there's a trust here, or I'm the real man on the land, or, all this other stuff, and immediately the comeback is of the judge is that you are incompetent and you need to be going to a psych evaluation, which is really a warning shot across the bow that's saying, hey, you're putting too much truth into this court, now you better keep your mouth shut. We keep on insisting and going into the court, and we waive our things, and they have to poo-poo all over it, and we lose it, and then we get under the arrest and the foreclosure. And here all our rights were really in that special secret place in chambers under equity. And here it was running, everything was a trust. And I keep on coming back to the more and more I study this, I see it more and more clearly as it being a trust. Has to be, because there's no money. If there's no money, we can't complete any contract transactions, or we can't complete any leaseholds, or we can't complete any exchanges of anything, really, because the measuring stick of which everything is valued at is zero. There's no money. If it's zero, then how can I put a value on anything? Then I can't trade anything of value for anything at all. I can't even give you a value of what cockle shells are worth. So I can't make a consideratable trade for value even with cockle shells, because we can't put a value on the cockle shells or anything else. So then what's left? Well, the trust came in to fill the void, because now everything became a gift, a gifting into trust, and the state has been the babysitter, the nanny, just like it said here on page 1, that in the words of the old counsel, the parents of the trust were fraud and fear, and the court of conscience was the nurse or the nanny. Court of conscience is trust. So our nanny has been the trust all along, where all the assets have been held in storage and waiting for the child to grow up and come awake and take over the trust. And if you knew what you were doing on the trust, then there would be no purpose for the trust. The trust would terminate, and both sides would be effectively merged, and you're back to where you were. You're back in Kansas. Any comments?
Christian, it's JC.
Yeah, JC.
Yes. So when you talk about putting things into the public, and we talk about the NOI, a simple, plain statement, your notice of interest, expressing the trust, and you come back in and have your SOI, is, from an evidentiary standpoint, are things like the commercial affidavit of truth where you are disclaiming the real man as a citizen of the United States or as a vessel?
Private substantive in chambers.
Citizen. Okay, so you think that's probably best served just in chambers only. Those shouldn't be in public recordings, and we should probably redact those if they were ever put in there.
Right. Just like I said under the definition of trade secrets, it's an insult to the public. It's a shock, just like what we talked about under the definition of legal fiction. state secret again, yeah. I've turned away from it, but so the disclosure of which would be contrary to public interest. Yeah, it's contrary to public interest on their public side, but maybe not under, common law republic. But in their realm, the way they are opposing, they're operating on the mirror image of what's in the private. So everything that we know and understand today in their realm is totally opposite. So what we think public interest for the public good is, we the people, they're going to think, no, it's not public interest, and it's contrary to public interest over there in their public realm. So anything of any kind of, I keep it out of their public realm. I come in with strictly colorable stuff. And, my teacher, Gene Keating, told me, he says, when we first started out here, he says, his court, that he was in one time, a judge told him flat out, he says, you don't have enough color in your pleading. In other words, you don't have enough lies in your pleading. Too much truth in a court.
So that begs the question, at what level do we reach competent jurists who would understand this? This is pretty heady stuff.
Well, I don't think we're going to have a competent jurist to understand this kind of stuff, and really I don't think I'd want to get it into the hand of a jury. I would want to have the judge do his duty according to equity, or else we're going to bump it upstairs to an appeal.
Well, I guess that's the judge has to accept. At what level will there be competent jurists, men, quote unquote, behind the bench that would be able to sit in camera and get this?
Well, I think that if we present them with the right kind of forms, the documents that they're accustomed to seeing, and we can get into chambers and present the evidence that is substantiating our claims, then I don't think they're going to be saying that, hey, I don't want to do this. I think they will do it.
Christian, you made a good point. They're not obligated to do that, though. Just because you send through letter rogatory, private chambers, registered mail, judge's eyes only, that does not mean that the judge has to put those documents into evidence under seal or even include those as part of the record. And so is it not possible that you could walk into court and ask for an in-chambers camera review, and judge says, no, I've seen all I need to see, and is there any evidence that you want to submit? And then
have you put a protective order on it yet?
You have no record to stand up.
Have you put a protective order on it yet? I think
there is a protective order in the matter that I'm involved in, yeah.
Yeah, see, the protective order establishes that it is trade secret information. If you don't have a protective order, the judge is going to say, no, I've seen all the evidence I need to see, because there's no reason to have a hearing, because there's no protective order demonstrating that it is trade secret information.
There's a motion for protective order and an order lodged with the court, but now the next step is the court has to rule on that and accept, reject, or some modification thereof for the protective order. So I guess my point is there's a couple steps, layers in there.
Yes, right.
The judge doesn't have to, in this case she doesn't have to approve the protective order and saying that I didn't make a prima facie case that there was a need for TCI protection.
Right.
So they could flat out reject it, and then, what's the next step? I send that whole
go to a higher
judge
court.
Chamber.
We go to a higher court. Because if they're not allowing me to defend myself because I'm claiming evidence, they won't allow me to bring evidence in that's trade secret information, then how am I going to defend my case? Isn't that a violation of American jurisprudence if they're not allowing me to bring in the evidence that I need to substantiate, and defend myself?
So you could just do an interlocutory appeal right there on the instant matter.
Say again?
You could do an interlocutory appeal just on that immediate rejection or denial of the motion.
Right.
Just for the evidence.
Right. I mean, that'd be a violation of due process right there, constitutional violation. But I can see
it seems
point of that also.
Seems to be. Sorry.
I don't want to really go in the courts and argue all this stuff. I see a different way, because these courts are nothing more than administrative tribunals anyway, and that's no different than the IRS, the Treasury, right hand, left hand. And if I did a Treasury Directive 25-06 calling a DIB hearing under Treasury, and I brought in the U.S. Attorney's Manual, that 6-4.010, which said that the records in the IRS, all other agencies, including the Department of Justice, has to comport to those IRS records, then if you completed your standing, corrected your standing in the IRS individual master file that you were not the trustee, and you set yourself up as beneficiary, then that's proof that all other agencies must comport to that I'm not that stinking fiction. But you see, we don't go back into where the root of it all came about, which is the one we created ourselves to be the trustee on the 1040 form, that we declared under forming a trust under declaration that we were the trustees because we made it out as debtors. But we haven't corrected that status. As long as we come in as beneficiaries some other place, say like Social Security, which the City Key Trust, it's not in line with the individual master file, which it must be. So you must be incompetent. So therefore, you need a nanny, and the nanny will take care of you the way the nanny sees fit. And they will give you a dog bone benefit until you get your record straightened out, and you show that you're competent by getting your record straightened out. Take care of your past debts, your present debts, and don't get into any future debts. Now you got the ability, I'll give you the whole trust fund here because now you're competent to handle it. Any comebacks on that?
Makes perfect sense. So what are those documents that unwind that relationship?
Well, we have to ask the question, who's the head of the IRS that has the say-so on that individual master file that we could call a Treasury Directive DIB hearing, and that would be the commissioner.
What was that book again on the DIB hearing? What was that citation you made?
It's Treasury Directive 25-06.
I'm sorry? Go ahead.
Treasury Directive 25-06. That's how you call a DIB hearing in the Treasury. Data integrity.
Okay, and you all, that's a data integrity board hearing, right?
Uh-huh. And then that U.S. Attorney's Manual, that 6-4.010, that's the one that says that all the IRS records, all the other agencies gotta match. So if I got the master file, why do you think they call it master file? Because everything's got to comport to that. And where we goofed up is we are the ones that are self-assessing ourselves to be the trustee on this whole thing by the 1040 form when we made a declaration of trust, appointing ourselves as status as trustee.
Yeah, of course, it's all self-assessment.
Yes. But now we can use that to our advantage because now we understand what we did wrong. We can come back in and correct that record.
So we want to go back and... I'm sorry, go ahead.
By calling it a DIB hearing.
Yes, and presenting the evidence to correct it.
And the evidence is?
The same thing that got you in there. The 1040 form got you in there. Because you made a declaration, you formed a trust, and you appointed yourself trustee. So you just use the same documentation, form a trust, correct the trust. If you were the grantor on the trust, you just have to modify in the trust and correct the positions. And then don't act like a trustee any longer, which is the debtor, according to this article right here. In the third line. Trustee is the debtor. By interposition of a trustee, the debtor, through thought to withdraw his property out of reach of his creditors. That's what they're operating by. They're thinking you're trying to get your property, withdraw your property out of reach of the creditors, and the creditors would be, say, the construment on them being the beneficiaries. They say that they're the beneficiaries, they're the creditors, under a construment because we didn't express the trust. So it all really comes back down to understanding this trust setup, how it operates, and coming back and expressing it the way that we want it.
Again, so the evidence to take into the DIP hearing would simply just be a declaration of a modification of the trust.
Yeah, that's an SOI, or that's an NOI, excuse me. But then you got to have the SOI to substantiate it, the material facts.
Sounds too easy.
I know. I think we make things too difficult all the time, and they've really picked something that is simple and they hide it in plain sight, like the DTC, Depository Trust Company. Well, it's a trust, folks. IRS, Trust 62. It's a trust. And if we start looking at everything as being a trust, when we go to buy gas, when we go to buy groceries, we're just forming a trust. Has to be. There's no money. Start looking at things like that, then I think we're going to see things differently.
Christian, it's JC again.
Yeah, JC, go ahead.
As part of your SOI, when we're going to put together a package and we want to go back and re-express the trust, every year the decedent files their 1040 and claims yourself as a trustee. So would we want to go back for how many years? Is that just maybe the last 3 or last 5, last 10 years? Re-express that particular trust, re-signing it as by grantor, for example, and then putting that on a package that then you can move and claim.
Yeah, what's the definition of privity of estate?
I'm sorry, I couldn't hear you.
What's the definition of privity of estate? Page 2, right at the bottom.
Knowledge of trust.
Anybody?
Knowledge
give
of
us-
trust.
Any-
Knowledge of the trust.
Yeah, well, that's just part of it.
Mutual right to the property.
Okay, well, does anybody have what I quoted? Anybody out there?
Grantor
It's a
agreement.
mutual or successful relationship to the same right and property as between grantor and grantee or landlord and tenant.
Correct. Now read it again.
A mutual or successive relationship
Stop.
to the same right and property.
Stop. Read it again.
A mutual or successive relationship.
Successive relationship. The straw man keeps on dying, and you keep filling out a 1040 form, making out a successive relationship that you are the trustee from year to year. Privity of estate. Privity of trust. Knowledge of trust. You must have the knowledge of the trust because you keep making out the 1044 form on a successive death of the straw man year to year, setting yourself up as trustee. Did you know that? That 1040 form is a successive trust. It's privity of estate. Any comments on that, JC?
Do you think we should? Yeah, no, I get that. That's fantastic. So do you think then it's relevant to go back and correct past records and correct the past declarations, or just make a simple change of status and then never go back into privity of contract again?
No, pro-tunk it, yeah. You guys have had it all wrong, and I have been incompetent up to this time, and now my competency has now been awakened, and I have been doing this all wrong, and that is my intent and my purpose, to correct all this and modify it, nunc pro tunc, all the way back to the beginning, correct your records. I am not the surety for this trust. I am the beneficiary. Now, I can play trustee position until I get that record corrected. Because in that point, I would want to come and say a court case and say, okay, I'm going to agree with you, public side jury, judge, that yes, I am the trustee, and yes, I did not make the payment. So now there's no controversy. The case goes away. There's no case. And let's go into chambers and talk about this. And while we're in chambers, Judge, oh, by the way, here's my legal reason why, as trustee, that I withheld payment, because there was a protective discretionary trust here, and per my discretion, I did not release the funds I withheld, which was under my legal right as trustee to do, because the beneficiaries, in this case the U.S., are bankrupt, and if I would have released the assets to the beneficiary and made a payment to them, the creditors would have seized their assets, which would be a breach of my duty as trustee, which I cannot do. And oh, by the way, Judge, here's a instrument to pay the debts of the beneficiary so that I would take care of all his obligations, and then I could release the funds. So either way, I'm a win-win situation, whether I'm trustee or whether I'm beneficiary.
So what instrument are you using?
It could be a bill of exchange. Just going to authorize the transfer of funds from one side to the other side just to zero the accounts. Discharge it on the public side or set it off on a private, whatever you want to call it.
So just a simple set-off would do.
Yeah. I authorized you to take X amount of funds out of the account, and if you don't know what the funds are, because I don't, I'll authorize you to take any amount out of there, except just send me a receipt.
They're going to love that.
Okay, here's some verbiage.
Christian, excuse me.
Here's some verbiage.
Whoever is typing, please mute out.
Okay, the verbiage. Trustee of the settlement may reimburse or pay and discharge out of the trust property all expenses properly incurred by them. So we're giving them instructions to do the discharge out of the trust property, whatever amount. And whatever amount it is, just send me a receipt. So this would be the receipt in writing of the trustee of a settlement, or where one trustee is empowered to act of one trustee, or the personal representatives of the last surviving or continuing trustee, for any money or securities paid or transferred to the trustees or representatives, as the case may be, effectively discharging the payer or transferor therefrom, and from being bound to see to any application of or being answerable for any loss or misapplication thereof. In the case of a mortgage or other person advancing money, from being concerned to see that any money advanced by him is wanted for any purpose of this act, or that no more than that is wanted is raised. Now that could be modified a little bit to fit our situations. Okay, it's getting top to the 12 here, 12 o'clock, so we're going to keep it down to about 2 hours every night that we do these. So if anybody's got one last closing question or so.
Nice work.
Pardon?
I said, nice work.
Hey, Christian, this is Matthew.
Yeah, Matt, go ahead.
The question came up about all this stuff, and really it boils down to enforcement, doesn't it?
Yes, true. But I think a court of equity is the vehicle that is going to be used to do the enforcement. I don't have to do it.
Whether that's the IRS or
the strength
or
trust. The strength of the trust is equity, where equity is going to compel the trustee to do his duty or prevent him from doing a breach of his duty.
Mm-hmm.
And as soon as the beneficiary makes a prima facie case, which is simple to do as much as just putting an affidavit in and saying that, hey, you never got paid, and if you prove trust, then there is a trust. Now you're the beneficiary and you make the claim. The burden of proof, the onus probandi, shifts on the trustee, and he's presumed to be guilty. And the only way he's going to prove himself not guilty is if he's got a record that he made a disbursement payment. If he didn't, the court's going to ask him, when are you going to make the payment? They're going to compel you to make the payment. Compare that to the summons in the beginning part of this article, the subpoena,
Yeah.
Where the writ of subpoena by which the trustee was liable to be summoned into chancery, that's a court of equity, and compelled to answer upon oath the allegations of the beneficiary. The setting key.
So, Christian, hey, it's Albie. So at some point here, one of the components to this process is that you're going to have to make a declaration as grantor of your beneficiary or beneficial holder status to the Sedeke Trust.
Well, there's 4 methods that I could use. 1 is declaration, 2 is transfer, and 3 is appointment, and 4 is contract. I could use any one of those 4, but the one I like to keep pointing out is number 2, which is the transfer, which under 2A is endorsement, 2B is delivery and bearer form, and 2C is assignment. And that's the one I keep coming back to. That's a UCC 3 assignment. And 2D is operation of law.
So that's for your SOI.
Yes, because declaration is really only used from when you are grantor/trustee, because you're transferring property within yourself, and you have to prove that by some kind of manifestation of your intent, which would be a declaration. Otherwise, a declaration would not be used for a transfer of property for a method of formation of a trust to a third party.
But will you not at some point, though, have to make a declaration of that Sedeke?
Well, no, I don't have to use
that it's your property.
I could use the method of transfer to form the trust. Declaration is only used when the transfer of property is within yourself as grantor and trustee within yourself.
Okay.
Hey, Albie, are you talking about the SS5 application and making a notice that you put into the county and the state, pull out certified copies?
No, I was actually talking about the Sedeke and making a declaration that I am the grantor and I am the beneficiary of that Sedeke trust. And then you would come back and do the SOI on the SS5.
Well, Christian, correct me if I'm wrong, but isn't the SS5 the actual document that creates the Sedeke trust? Isn't that what you taught us?
Yeah, that's what I would say it would be, yeah. That's the application, original application, whoever, my mother did it for me, I guess, when I was younger, or you did, or whatever.
So you taught us to redo that, sign it as grantor, make a copy of it, and then send it in via notary due presentment, the copy, not the original, hold on to the original.
Right,
and then make a notice that goes into the county, pull out a certified copy that's witness number 1, and then a UCC 1 that goes in the state, pull out a certified copy that's witness number 2, take those 2, attach them to the original.
Right.
And now you have your SOI.
Or proof that
Statement of intent.
Sedeke was you're the grantor and beneficiary, right? Just that trust. Right. But all other trusts are trying to get into that one. All other sub-trusts are trying to get into that trust. But I might want to just take, say, like a court case and just treat it as a trust itself, and I could probably just win just by that alone, not even coming in and proving trust on a SETI K trust, the Social Security account. But the declaration, what I'm talking about, is on page 79 of Gilbert's, where under B, creation of inter vivos trust, example number 1, which is section 265. It says requirement of effective present transfer, so it has to be a present transfer, or declaration. It says to create a living or inter vivos trust, there must be an effective present transfer of the trust res. The conceptual problem exists regarding a declaration of trust. The present declaration may be said to substitute for a transfer, but it could also be said that there is a transfer from settler as an individual to settler as trustee. The latter approach is followed here, but the question is essentially semantics and moot. So the declaration is, grantor as trustee. It's like you're transferring property within yourself, and the only way you can really know that that was done is if somebody makes a declaration and forms a record of the manifestation of his intent and purpose, that he actually made a transfer within himself, or else nobody would really know. Couldn't prove it.
Christian?
Yeah, Rhonda.
How you doing?
Good.
The way I see it is pretty much right now, on anything that we're dealing with, we're pretty much going to have to act as the trustee, because that's what the IRS status has us
Right.
in.
Well, now we put ourselves up in the IRS.
Right, and since all other records have to comport to that, until we change that, we are going to have to be the trustee and go ahead and make the payment.
Correct, and you're the trustee, the one who can make the payment. But now under effective discretionary trust, I got a legal reason why I withheld, because you beneficiaries are bankrupt, and I can't release funds to you guys. The creditors will seize it, just like under bills of attainder. What section was that again? That was in bills of attainder, or not bills of attainder, excuse me. Bills in equity, excuse me. Bills in equity was
456.
Yeah, 456, page 130.
Creditor bill and equity.
That's just exactly what we're talking about right now. Creditors
Or
equity, or its equivalent.
We could do that, possibly like if somebody sent me as the trustee a bill to pay, I could go ahead and write a money order and pay it, right? Or a BOE.
Yeah, in chambers, yeah. You could submit that promissory note or that money order, that private credit, that private negotiable debt instrument, or non-negotiable debt instrument, excuse me.
Well, could I pay it, could I provide my private credit before we get to in chambers? So, like if I'm the trustee, I accept the property they sending me, that part of the property, and make the record to send it back. So now I have a record that I did pay it. So if then they want to go to court, say I try to say I didn't, I got the record that says yes I did. It's right here. Here's the transferred property back to them.
That quite might work. But
well, I mean, if you pay
you're
them,
pressing the
you got
in chambers and proving the fact that there is a trust, and then you could prove the fact that you made a trust deposit. And trust deposit under Black's third revised, or fourth revised, is a trust deposit where money or property is deposited to be kept intact and not commingled with other funds or property of bank, and is to be returned in kind to the depositor or devoted to a particular purpose or requirement of depositor or payment of particular debts or obligations of the depositor, also called special deposit. And then we pull up the restatement of the seconds there under section 342, which talks about the conversion. And if I prove trust, then I've got the ability to direct or order or declare that they do such and such. And under 342, without me pulling it out, it says that I have the right to order them to do a conversion of trust assets. And then with the statement that we just talked about there, we're going
but all that you just said,
the trustee of settlement discharge out of trust property all expenses properly incurred by the debt, say, whatever obligation.
But there you're talking as a beneficiary, because it's a beneficiary who has to prove the trust.
No, I thought we were talking about trustee.
Yeah, we're talking about. But why would if I as the trustee sent the property back to the beneficiary to make the payment, why would I want to go into chambers unless they're going to be the ones that's going to try to go into chamber or go into court to say I didn't pay it, and then I can say, yeah, okay, now they've got trying to bring the trustee in court saying the trustee didn't make a payment, but I can go in and say, okay, let's go back in the chambers because I have evidence that there was a payment made.
Okay, but if you're a beneficiary, you have no right to make a payment.
I'm not beneficiary. I'm the trustee. I think that what they have us on is that the IRS master file, they're seeing us as the trustee.
Right.
Until we get that changed.
I'm getting confused. I thought you meant trustee, but then you're talking about beneficiary, and I thought you're beneficiary, but now you're still talking trustee.
Yeah, because when you was reading about the proving the trust, that's the beneficiary that has to prove the trust to get the trustee, to obligate the trustee to pay.
No, the grantor.
But out here,
the beneficiary can make the claim, yeah, that he didn't get paid.
But out here, the way they're seeing, because of the way the IMF master file set up, we're seen as the trustee.
We're seen as a trustee, correct? Yeah, and he's the only one who can make a payment.
Yeah, so somebody sends me a beneficiary that's listed as a beneficiary now until I get that record changed. They're listed as beneficiary. The state, the bankrupt U.S. corporation is listed as the beneficiary. They send me a bill. I'm listed as the trustee. So probably for now, it would behoove me just to go ahead and write out a money order and claim the property and assign it back to them for the payment.
Yeah,
now,
you
I have evidence that
trustee
I did
make the payment, but then here's what may happen. They may say that it's discretionary and might not allow you to do
trustee.
At all.
I thought only the trustee could decide if it's makes the discretion whether to pay or not.
Yeah, that's correct. Excuse me. Yeah, I was confused with the old bankruptcy. Where if you establish yourself as trustee this time on account to be able to do it all, yeah, then you're withholding yourself, and then you can make the payment. Correct.
And so I can just go ahead. So until we get that IMF master file changed as grantor beneficiary, right now it's grantor trustee.
Yeah, well, conflict with the key.
Yeah, so if I come out here in the court right now and try to say, hey, I'm a beneficiary, well, that's in conflict with the IRS master file. It says trustee.
You'd either have to get rid of the setting key trust, correct that to be different, and then you wouldn't be beneficiary any longer, so that your trustee would match with the IRS master file, or else correct the master file so it matches the setting key, so that you wouldn't be declared incompetence.
Yeah, I think I'd rather be grantor beneficiary instead of grantor trustee. What do you think? Which would you rather be?
Well, I think I would rather function as a beneficiary and take over the whole ball of wax. But if I ever got pulled into court, then I would function as a trustee.
Yeah, well, right now we pretty much don't have a choice because that's how we're listed. That's how they see us,
right,
as a trustee on that account.
Yeah,
before I change that master file.
I act as beneficiary in court, but I think it's better that if I agree with them and I am trustee, and that way there's no controversy. The case disappears, and I can go into chambers there and then make that payment.
Right, because
I have a specific question about that in chambers part. Do you not have to then actually prove certain issues, like you're telling the judge that the U.S. is a bankrupt corporation? He might just look at you cross-eyed, but you have to bring some other data in there that's going to explicitly state that or prove that in chambers, or you still might go for a recycle eval. That's one of the big problems I see with coming in as a trustee and trying to express that component of it. Why did you withhold payments if you're the trustee? You can't. I can't because it's discretionary because the beneficiary is bankrupt.
True, right.
But now you have to prove the bankruptcy of that to the judge in chambers. And
no, that's up to the opponent. That represents conclusions based on facts, not any evidence at all. So if he objects, so I'm putting the prima facie case that it is bankrupt. He has to come in with countermanding evidence to support that it is not.
And would you just bring that into the chambers by affidavit then?
Good, yeah.
You could probably just write them and get them in an agreement that they're in bankruptcy with you.
Well, I don't know if I'd want to opt their creditor stuff. I just want to make, it's like we're back under the right side of the court now, and when we make a statement, then they're going to have to come up with the countermanding evidence to negate that prima facie evidence we're bringing in there. It's like we got our rights back.
I like that better.
Like they've been getting us all along on this public side, because they say it's been functioning as admiralty. Well, here it was not admiralty at all. It's really trust, because if you look at it, the way we've been thinking was all admiralty. Admiralty, you're coming in there for a breach of contract, breach it because you didn't make a payment to them, and then you slide into equity for the enforcement to compel you to do it. And when you can't make the payment, you're in breach of the whole shebang and end up in jail as a trustee. Well, here it was trust all along, because that's exactly what a trust does. But now we're making it's on our side instead of on their side. You know, because we as trustees, you know, it's like we got our rights back. You know, it's just like, wow, there it is in that one secret place in Chambers. There's where they hit our rights. They've held them in trust in Chambers. So it's like the onion skin being peeled back to the next layer, Finally, we found out that in the core of the center there, where there was a trust. So if we look at it for the way that we see that it is, the way it's operating, not by the layers of lies they're hiding it by. Whether you're going to call it admiralty or debtor-creditor or law merchant or UCC or whatever, here it is all at the core of trust. And really, the basics of the trust is, you know, very simple: 10 purpose, party, specific, res, and one method of formation of the trust, whether it be a declaration, transfer, appointment, or contract. Establish that, prove that with the facts, make a prima facie case that I didn't get paid, which is easy, and now the court looks at it as the other party is guilty. So anyway, we're going past time, so we'll continue on with the instructions on page, where did we leave off? Page 3? Yeah, privity as regards to the SETI Key Trust. And we'll pick up next Monday.
Thanks, Christian.
All right. See you then.
Thank you.
Let's see, today's Monday, so I'll see you on Tuesday, to Tuesday's call. And it's probably going to be a different number than DimDim. I think I'm going to do away with the DimDim. I don't care for the DimDim.
Neither do I.
I think we're just going to use the whiteboard just like we're doing right now, the Share Plus, and we're going to use the other number, which is, let's see, which number is it? Well, it'll be the same number we've got here. That's 712-432-0075, and that's access code at 917030#. Also, if anybody didn't hear last Saturday's show, I announced the workshops. And, I have a website up now kind of explaining the details, and the website address is movingtitles.com. So just go to movingtitles.com and check out the webpage for the explanation of the workshop. I'm trying to make it a little more clear because I guess some people aren't understanding what I've written in there, but there's two options there. Option one is really, let me pull it up quick. There's going to be two options. I haven't got a chance to update it yet. Option one is $2.99 for one workshop. Option two is 2 successive workshops for $4.98, which is a $100 savings off 2, or $50 savings per each one.
Which would cover everything?
The workshop is for 2 hours per session and 2 sessions per week, so that's 4 hours per week. And then it runs for 5 weeks, or a total of 20 hours.
Christian, I was thinking you were going to charge like $2,500, so I really appreciate the hell out of you. I just want you to know that. Sign me up for both.
All right. Well, have you ever made a request at NTT registration at movingtitles.com?
Oh yeah.
Okay.
Yep.
So we have to take a 20-hour course. Is that what you're saying?
The workshop is a 20-hour course.
Christian, what's your vision for the trust ambassadors? Are we all people here and people not on the call, everyone who's signing up, going to be a trust ambassador? Or is there some particular purpose for the 20 participants on the call right now?
Well, the trust ambassadors are really the ones that are heads of their own group that want to get, say, like 12 or so people under them, and they want to teach what they're getting to somebody else. That's the requirement. And then I'm going to take those, say, like my 12 that are the trust ambassadors, and I'm going to work close with them. And then those 12 have 12 of their own in their own groups. and we just kind of like filter the knowledge down through. So anybody that's within your groups can attend the calls, but I won't be able to address everybody in the group. I'm only going to focus on, say, my 12. I can't handle so many people. I've got a hard time keeping up with emails.
You need to clone yourself.
Yeah, so I can't take care of more than, say, 12 people and give, so those 12 are going to have to pass the information down through. What I plan on doing was maybe within the 12 that of each group, I would spend like once a week with a group meeting with them, and whoever's in their group, and then we'd cycle through the groups.
Well, you actually are cloning yourself with Trust Ambassadors because you are duplicating.
Yeah, I'm going to duplicate
your work with others.
12, and then those 12 duplicate themselves and their 12s. And we go down a couple layers deep, then the knowledge will be passed on.
Well, who are your 12? Because there's like 18 of us, I believe.
Yeah, well, I really haven't decided yet. So I'm going to pick about 12 people to work with.
Okay.
Okay. Well, if you have any questions, email me at Christian@movingtitles.com. Or you could do my regular email boxes at Hushmail or Hotmail, But check out the website, movingtitles.com. And work in progress, we'll be updating, adding new information and stuff onto that, So if anybody has any web talents or stuff, let me know. Probably I could use the help. All right, well,
thanks, Chris.
Okay.
Great call.
If not, then on Wednesdays, call at 8. And if not, on Saturdays then. Otherwise, I'll see you next Monday. Have a great week.
Are these calls through TalkShoe, Christian?
TalkShoe's on Wednesday, same number. It hasn't changed. Tuesdays probably will change to this number I just gave you, which is the same number we're using for this, because I'm going to eliminate the dim-dim. I don't think it's necessary now. We can do the whiteboard with the share here, and once we get that done, we're running a hybrid system because the regular call-in number that comes with share doesn't have Skype access, so we're not using that call-in number. We're using a totally different service, which has Skype to get in on Skype. So if anybody's dialing in long distance, they're getting charged for it. If you can do Skype, you can Skype in on this call with this number using Skype, and still we'll have the access to the whiteboard and stuff.
And that's Tuesday evenings at 7 p.m.
Yes, Tuesday's call with Dim, which was the 605 number, will no longer be. So if tomorrow, try one more time to get under the 605, because I got it set. Tomorrow may be the last one for using Dim under the 605 area code. If you can't get under the 605, because I think my trial has ended for it, and I'm not choosing to sign up for it, so I'm not sure if I'm going to have a call under the 605 Dim tomorrow or not, but it is technically set using a 712-432-0075, and that PIN access number to get in the same way we did here tonight, 917030. It's either going to be one or the other tomorrow night.
7 p.m. Pacific time.
That's at 10 o'clock. 10 o'clock Eastern time, my time.
Oh, okay.
Which is 3 hours difference Pacific. Is that where you said you were? Yeah, 7 o'clock your time,
yeah.
I believe. Okay. 10 p.m. Eastern, my time. Make it easy for me.
Okay, thank you, Christian.
All right. Good night, all.
Good night.
Good night, Christian.
Good night, everybody.